Okay, hello and welcome. This is Abhinav, and in this video, I am trying to capture my learnings from a very important judgment that has come by the ITAT, and this is the ITAT Delhi bench. Very recent judgment that is like 5th September 2024, where the Delhi ITAT has said that US LLC qualifies as a US resident under the India-US DTAA Article 4. So let us examine that judgment. It's a recent decision reported in 2024 166 taxman. So in this judgment, what were the facts? So first, let's understand the facts of the case, what the tribunal held, and then some other thoughts and questions that I have on this judgment and its overall impact on the LLC type structures across the world. Right. So facts of the case were that the assessee company claimed to be a resident of USA. So just to make things clear that under the DTAA there is an article 4 which defines resident, and according to that particular article, the company claimed itself to be a resident of the USA, right? Which the LLC as a resident of the USA, and offered to tax the income which that it got on account of fees at a lower rate of 15%. So the normal tax rate as per the Indian tax law was 25%, and they claimed the lower rate, claiming that they were eligible to the tax benefits as per the India-US DTAA. Right, so they claimed a lower rate of 15%. However, the assessing officer denied the treaty beneficial rate and charged the income at the normal provisions of the Indian Income Tax Act at the rate of 25%. So now the assessees, so I read the entire judgment, and the assessees' main contentions were that the status of the assessee was a limited liability company LLC, and being a fiscally transparent entity according to the US tax laws. So LLC is a fiscally transparent entity. So how basically the taxation of LLC works is that the income of the LLC is taxed in the hands of the owners, right? And it has an option to elect it as a corporation or or being disregarded, right? So the assessing officer's point was that it is a fiscally transparent entity according to the US tax law. The income is not subject to tax in its own hands in the USA, and that's why the the assessing officer relied on Article 4 of the India-US DTAA, the language of the Article 4, and concluded that the corporation, the LLC in this case, does not qualify as a resident of US in terms of Article 4, and only persons or entities that are liable to tax in their country, in this case US, as per the tax laws of that country, that means the US tax law, are considered as resident. So basically, assessing officer's point was that it is a pass-through entity, it is a disregarded entity as per the US tax law, right? And second thing was that it is not liable to tax in US, right? And that's why it should not be considered as a resident. It doesn't fall in the four corners of the DTA article of resident. That's why since it doesn't fall as a resident under Article 4, the benefits of the India US DTA cannot be given to the assessee. Now, the AO in his in their contentions, they also relied on the guidance on the OECD Model Convention commentary with respect to partnerships, whereby the OECD Model Convention says that partnerships are fiscally transparent entities and hence are not do not qualify as residents. And taking cue of that commentary on Article 4 OECD Model Commentary, it said that the LLC does not come under the special clause of partnerships and trusts under Article 4. So that was their argument. Now let us discuss what the tribunal held. So the tribunal heard both the parties, or assessee's contentions as well as the assessing officer's contention, and the tribunal held that under the US tax law, an LLC with a single owner is disregarded as separate from the owner unless the LLC elects to be treated as a corporation. So this is a set understanding, right? Okay, now ability of the LLC to elect its tax classification under the US federal income tax law supports the legal situation or aspect of the LLC being liable to tax. So the important thing, what in this judgment the tribunal inferred, is that the ability of that LLC to be classified as a corporation, right? This supports that legal situation of the LLC to be a separate standalone entity liable to tax. Then the tribunal said that where the LLC is disregarded as separate from the tax owner for US federal income tax purposes, the tax owner of the LLC pays tax on the tax owner's share of the taxable income attributed from the SSE. This further supports the legal situation of the LLC being liable to tax. Only the discharge of the tax is done by the owners of the LLC. So this is a very, very important point in case of such structures. So what the basically the tribunal said, that that the LLC was liable to tax. Just the discharge of the tax, which was not in the hands of the LLC, was done by the owners. So it was more of a kind of a convenience provision in the tax law, in the US tax law, that the discharge of the tax liability of the LLC is done by the owners. This doesn't mean that the LLC doesn't have a separate legal position, legal standing, right? So the basically the court said that the mere fact that the LLC has its own tax obligation, which then is discharged by the partners of the LLC, is is basically supporting the fact that the LLC has a standalone perpetual standing. Then what the basically court did was, the tribunal did was, they relied on the wordings of the tax residency certificate that is received from the, that is given by the Internal Revenue Service in the US. So they relied on the wordings of the TRC, and they said they actually, the in the judgment it has been very clearly mentioned the wordings, how the IRS issues the TRC, and it said that it fulfills all the requirements of a legal regulation recognition of the separate entity, of the existence of the entity from its member, and a perpetual existence which is distinct from its members. Thus, the tribunal opined that the LLC in this case qualifies as a separate person liable to tax, and hence, so it's a separate person from the wordings of the TRC, from the fact that that it has a tax liability that arises. Only discharge is done by the other person, and liable to tax. That means they said that it is liable to tax. They relied on the Supreme Court decisions in Azadi Bachao Andolan and all those things, and they said it's liable to tax, it's a separate person, hence it qualifies as a resident under Article 4 of the India-US DTAA, and can claim the reduced tax rate of 15%. Right? So this is a very, very important judgment, and it will impact, and it will be kind of a favorable judgment for like Indian residents who hold businesses, who have overseas presence in terms of LLCs in US. So in respect to the payments to those LLCs and all. But then I have certain thoughts and questions in this judgment. Now, my point is that even though this judgment is there, this subject of Indian tax department ignoring the separate status of the LLC, and disregarding that status for the purpose of giving the treaty benefits, will be there even after this judgment. There will it is this particular area is always pro litigation, and so that litigation risk will be there, and it remains to be seen whether the income tax department appeals against this judgment in the high court. Now, even in this case, see, their point was, the income tax department point was, that they relied on the OECD model convention with respect to the partnership, and they said that OECD model convention, the commentary, now that commentary cannot be like it's not a conclusive thing, right? So in this case, what happened, they said it's not a partnership. The court disregarded that particular point, and the court disregarded their reliance on the OECD model convention language by the ITAT. However, it may not be there in the other cases, right? So in this case, fortunately, so it's like a favorable judgment as a for the professionals and for the people who are in tax practice. They can use this judgment. However, it's still prone to debate. Now, reliance was placed on the Linklaters case. So what the tribunal did was, it disregarded the assessee's point on the OECD model convention on partnership, and it placed its reliance on the Linklaters case. Linklaters case was based on a UK related taxation aspects on PE, right? So that judgment is again has come to light, and it's important for, as CA professionals, we need to study that judgment in detail and take out any other favorable points which are not captured in this judgment but can be taken from that judgment. So that judgment holds importance. The Linklaters case, Azadi Bachao Andolan, was relied upon for the contention relating to liable to tax. So now it's like a kind of a settled position on liable to tax, right? So that is very, very clearly the tribunal said that the LLC is liable to tax. Only the discharge of the tax was done by the members of that LLC. Now, a question is whether this type of this judgment will apply to the LLC type structures in other jurisdictions, right? Maybe in other jurisdictions that have the similar structure where the LLC is disregarded and the liability of the tax liabilities on the individual members of the LLC in because here in this specific case was of US LLC where the LLC could opt for a election as a corporation or treat itself to be a disregarded. However, in other type of a jurisdiction, whether that same benefit is not available, if not available, then will this judgment hold good in that case? So that remains to be seen. Now, one more important thing is that the ITAT in this case strongly relied on the wordings of the TRC. The wordings, what the wordings that the TRC are contained. So we, as professionals, we also need to, when we guide our clients, we also need to study the wordings of the TRC issued by similar jurisdictions. So if we are taking a case with respect to any other jurisdiction, a similar structure, so what is the TRC wordings if we can get from the client on such cases, and then also study the wordings of the TRC, because tribunals and courts can also rely on the TRC wordings for the purpose of giving a judgment in such a case. So these were some of my points. I hope they were useful in some way. Do share your thoughts and feedbacks in the comment section. Thank you so much for watching this video. Thank you so much.